Chairman Peters, Ranking Member Paul, and members of the committee, thank you for inviting me to testify before the committee today. I am Jessica Tillipman, the Associate Dean for Government Procurement Law Studies at the George Washington University Law School. Over the past several years, organizational conflicts of interest, or OCIs, have received an increasing amount of attention given high-profile incidents that have highlighted weaknesses in this area of the law. Although I was very pleased to see the enactment of the Preventing Organizational Conflicts of Interest in Federal Acquisition Act, which addresses several gaps in the current OCI framework, given that the Federal Acquisition Regulatory Council has yet to issue a proposed OCI rule in response to that legislation, this hearing provides an opportunity to renew focus on the issues that continue to hinder federal agencies' ability to effectively address OCIs. Today's hearing focuses primarily on a specific type of OCI, impaired objectivity, which may arise where a contractor's outside business interests and relationships create an economic incentive to provide biased advice under a government contract. Although OCIs have been regulated since the 1960s, they've become more frequent in recent decades due to industry consolidation and the outsourcing of services traditionally performed by the government. OCIs are more likely to occur in contracts involving professional services, including management support, consultant, or advisory services, which is notable given the hundreds of billions of dollars the U.S. government spends each year on these professional services. Despite widespread acknowledgement for the past several decades that this could create fertile ground for conflicts of interest, government regulation of these potential hazards has not kept pace. The decades-long absence of an update to the federal government's approach to OCIs has weakened U.S. procurement system and left it vulnerable to integrity and national security risks. Today's hearing is focused on a potential national security concern that may stem from companies that maintain intelligence or defense contracts with the United States while simultaneously contracting with foreign adversaries. If these interests are neither disclosed nor mitigated, it increases the risk that sensitive information may be exploited or fall into the wrong hands. It also increases the risk that contractors may be unable to provide impartial assistance or advice due to their competing relationships with certain foreign governments. The current framework governing OCIs, which has remained largely unchanged since 1984, is outdated, inconsistent with modern procurement practices, and fails to address the growing risks associated with the government's increasing reliance on contractors to provide services which include advice and the exercise of judgment. This has led some contracting officials to treat OCI assessments as a rote, check-the-box exercise rather than a meaningful, thorough, and rigorous analysis. Moreover, the lack of a standard FAR OCI solicitation provision or contract clause has left agencies to fill this vacuum with their own provisions and clauses, leading to severe inconsistencies in agency approaches to this area of the law. And most glaringly, the FAR lacks critical definitions and does not thoroughly address compliance, disclosure, or mitigation obligations. This absence of guidance has led to a paradoxical issue of both over and under compliance. Some contracting officials may never even consider OCI risks, whereas others may reflexively and improperly exclude a contractor from competition. A new OCI rule should provide clarity, more expansive definitions, greater guidance for contracting officers, updated illustrated examples, and enhanced disclosure and compliance requirements for relevant contractors. This effort should be buttressed by robust training requirements for contracting officials as well. As this committee and the FAR Council consider remedies to these issues, a cautionary approach is necessary. Draconian approaches to addressing concerns can not only undermine the goals of legislative and regulatory reform, but create new problems. Striking a balance between necessary and excessive regulation is never easy, but it's critical. And it's my hope that a thoughtful and nuanced approach to OCI reform will address integrity and security concerns, bring greater clarity to the existing regulations, and create a more uniform approach across the federal government. Thank you for the opportunity to share these thoughts with you. I would be pleased to answer any questions you have for me.